Welcome back to Supreme Myths after our 3-week hiatus. I guess this is kind of season 3 of this podcast. I hope everybody had a safe holiday, and not much has happened, so there isn't much to talk about. No, I jest. I'm really excited today to have as my guest Professor Franita Tolson. She is a professor of law and vice dean for faculty and academic affairs at the University of Southern California. She's a graduate of Chicago Law School, where she is visiting virtually this winter, which is, I think, the best way to visit anywhere in Chicago, virtually that is. She clerked for 2 federal judges after law school. She is a nationally known expert on election law, one of the reasons she's here, among many. She's a commentator for CNN, the author of too many articles, op-eds, and essays to name, but she does have a new book coming out with a fantastic title, I think, In Congress We Trust, Enforcing Voting Rights from the Founding to the Jim Crow Era, which I'm not sure has ended, but we'll talk about that later. Franita, welcome. Thank you so much for being here.
So excited to be here, Eric. Thank you for inviting me.
Oh, it's my pleasure. We tried to do this during the election. You were too busy. You were too much in demand. So I'm glad I was able to get you this week. So normally I start by asking my guests to mention 3 myths about whatever they're an expert in. We'll do that second. First, we're going to talk about current events. The article of impeachment, and I use the word article because I'm very upset about it, just came out. And it alleges, incitement to insurrection and all that. It mentions the Georgia phone call that we have a tape recording of, but it's not a separate article.
Right.
My first question about current events is, do you agree with that strategy?
This is so unprecedented. I would be remiss if I sort of pretended like any of this is normal. I'm not sure if it's right or not, and I'm happy to admit that. Like, I see the benefit of it, right? It keeps it streamlined. It keeps people focused on the most recent sort of transgression, because you have to keep in mind that this president has been a habitual norm breaker. And theoretically, we could have had separate articles for a number of things, right? It's just that I think people are so shocked and so focused on what happened on January 6th that perhaps it makes sense as a strategy to get people on board, because it does seem like more Republicans are speaking out about what happened on January 6th as opposed to speaking out about what Trump did with the Georgia Secretary of State. So it could be part of a larger political strategy, but honestly, I'm not sure what's right anymore. I just, I'm so disturbed and so terrified and so stressed that I just want him gone.
I agree. I'm hoping Pence does the 25th Amendment, but he won't, probably.
It will be, to me, the most straightforward way of neutralizing him, right? Because I think some of the concern is what he'll do in the next 10 days. The time from the Georgia Secretary of State call to the storming of the Capitol, that was like 100 hours. I mean, he wreaked that much havoc in 100 hours.
Right.
So I shudder to think about what he can do in a little over a week. So 25th Amendment makes the most sense to me, but I just don't think that Pence will be on board.
Let's talk about the Georgia phone call for a second, because I've listened to it, and there is no question. It is on tape. It's not like the Ukraine phone call. This is a phone call that we have a tape recording of. And in that phone call, he clearly tries to coerce the Georgia Secretary of State to, quote, find votes. Those are Trump's words. But the reality is, when he says, find votes, he means make up votes. That's what he means. How can that not be an obvious abuse of power? A president can't do that, right?
Right. So I agree that it is an abuse of power, but I think that's different than getting a criminal prosecution. So much of the election laws turn on state of mind. And to me, this is the perversion of it all, right? Because it might actually be difficult to prosecute him if he actually believes his delusion, right? So if he's saying to the Secretary of State, find, 11,780 Trump voters whose votes aren't being counted because of this widespread fraud, and he actually believes that, then it becomes more difficult to prove that he's actually trying to encourage a solicit election fraud, right? Which is bizarre, right? Because we're faced with 2 possibilities. Either the president has committed a felony, or the president is a delusional person who believes in unicorns and dragons and everything else, right? Like,
or both.
The Republicans in a really bad place.
Yeah. So one last question about impeachment, I think.
Okay.
My view has been, and I don't think I've changed it, I think they can clearly the Senate can try. He can be impeached after he leaves office, I think. Do you agree with that?
Yeah, I agree with that.
Okay. I mean, to be fair to the audience, it's an open constitutional law question, but no court is going to second guess it. So it's up to the Congress, I think. Is that fair?
We can also agree that it's not justiciable, right, Eric? That the courts wouldn't weigh in on this question.
Exactly. I think the court has suggested that in other impeachment cases. I think it was suggested here. All right. That being the case, he's not going to be impeached before January 20th. There's no way the Senate's going to do that. I mean, convicted before January 20th.
Right.
So to me, the House is, again, making the mistake they kind of made last time. I think they're rushing it and oversimplifying it when they don't have to do that because it can't finish in time anyway. And as you pointed out, I think 5 minutes ago, we could probably list 5 to 8 impeachable offenses over the last 4 years. I wish they would take their time. I mean, I don't know what the rush is since they can't get him out anyway.
I think it has to do with political momentum, right? So the momentum is behind, the most recent transgression. And so I think that is perhaps why they're focused so narrowly on just looking at what happened on January 6th. In terms of strategy, though, keep in mind, we are living in a time in which people have their sense of focus, like the attention spans are so short.
Yeah.
So it makes me wonder if the American public has an appetite for a lengthy proceeding, impeachment proceeding, where the House lays out all of the different things that Trump has done, or people will lose focus. You can't tell me that they aren't also thinking about that as well. The fact that people may not have their attention for much longer. Excuse me. And so that may be why they're just focused on this one narrow thing that everyone is universally outraged about.
Fair enough. Well, as a lifelong Democrat, I know you are too, I assume. I hope they do. We kind of aren't that great at this kind of thing, and I hope we do this one better. That's all.
Yeah, we missed the boat a lot.
Yeah. Okay. So let's turn to your real specialty, which is election law, or just elections in general, voting, election law, whatever, defined as broadly as we can. Go ahead and identify, if you can, 3 myths about elections in any way you want.
I had to think about this one.
Yeah.
So the first one would be that this myth that elections only matter every 4 years.
Right.
I do think one of the lessons of the last 4 years has been that election law matters all the time. Right. It matters for not just the midterms, not just for elections at the federal level, not just for president. It also matters locally. It matters for state legislatures. We're about to enter into another round of redistricting. Right. The census numbers are coming out. And so it matters which party leads up the state legislature as you embark on that process. It sets the districts for the next 10 years, possibly shorter, Eric, as we know from the case law, but at least the next 10 years in most places. And so elections matter across the board. And I think people are really, really learning to pay more attention to elections beyond president.
I think that's a great point, and I'll get back to it. What are the other 2?
So the second one is when people say that we are in a republic and not a democracy, that's always a bad argument. Stop saying that. It is nominally true, but we are a republic that has embraced democratic norms for well over 2 centuries. There have been fits and starts. There has been backsliding, but generally speaking, we have been moving in a democratic direction. So that doesn't settle any arguments. Instead, it just makes election law people mad. So that's the second myth.
And that one, by the way, I completely agree. And Neil Gorsuch's book, which is called A Republic If You Can Keep It, is horrific from page 1 to the end. But that's one of the reasons it's horrific, because he seems to focus heavily on this idea versus republic versus democracy. All right, sorry. Number 3.
Right. And let me just piggyback on that.
Yeah.
Republic actually embraces a number of different types of government. A republic is not even necessarily inconsistent with a monarchy, which is something that people don't understand and appreciate. Right. So stop saying that. So that's the second myth. The third myth is, I kind of went back and forth between, and let me look at my list. Your vote doesn't matter. That's a myth that people believe. But I think I have one that's more important than that.
Yeah.
This idea that the Supreme Court can disentangle itself from politics. We saw the court kind of attempt to do that with the Rucho decision, right? Rucho versus Common Cause, which is the case where the Supreme Court held that partisan gerrymandering claims are non-justiciable political questions. And so I think that is also a myth. right? I think in the 1960s, when the Warren Court first became really embroiled in politics, and we got one person, one vote. We got the court recognizing an implicit right to vote in the Constitution. The court heavily policing the political sphere with respect to race, race discrimination in voting. I think that opened the door, and you can't close it. And so these claims will appear in just a different form. So you'll have more partisan type claims under the Voting Rights Act. You'll have more partisan type claims under other branches of the 14th Amendment and the 15th Amendment, given the overlap between race and partisan affiliation in this country. And so it's a fool's errand to think that the court thinks that it can just simply remove itself from this sphere. And in fact, that probably causes more damage and fixes nothing.
Right. And on that last third one, I mean, the court didn't view Shelby County as a political question. And it does seem to me how much progress we've made on race when it comes to voting, in Congress's opinion, should be Congress's judgment to make.
No, absolutely. And that sort of ties into my new book, which if I ever finish writing it, it's just...
hold that thought for 1 second. We're going to get to your book. I want to go back to myth number 2, because I think myth number 2 is also at the intersection of your work and is so important. And this might be controversial to some. I think you and I are going to agree on this maybe, but I think to others it's going to be very controversial. My reading of history is that when Benjamin Franklin said, I think it was Franklin, right? A republic if you can keep it. When he used the word "you" in that sentence, he was referring to white propertied landowners. Right? When he said that, only white property landowners were voting. I don't think he was referring to the people. I think he is their ideas of a republic are quite different than how America should or does view itself today. And that's why I think your second myth is so important. You think I have that right about Franklin?
Well, so Franklin was actually a little bit more progressive on voting than some of his colleagues, because there's this famous Benjamin Franklin quote where he says, "In whom is the right of suffrage? Is it in the man or is it in the donkey?" Right? Because that goes to the point of when people own property and they lose that property, they lose their right to vote. And so technically, it's like the property can vote, but the man can't, and that made no sense to Franklin. So
okay. I didn't know that. Thank you.
No, of course. He was actually one of the early advocates of getting rid of property qualifications for voting for this reason. But I do think you're right in the sense that they were still thinking about the electorate fairly narrowly, although I also want to dispel the notion that women and Black people weren't voting in the founding era. In some states, they did vote, and sometimes it was through drafting errors, right? Massachusetts, for a time, African Americans were voting because of a mistake in the statute that they fixed. But there were, and Eric, I'm sure you've read Dred Scott. You know that Justice Curtis in his dissent pointed to the fact that African Americans were voting as evidence that they were fit for citizenship.
In dissent, we should make it clear, in dissent.
In dissent, right. And so one thing I've realized in sort of looking at this notion of a republic is that people had very different conceptions of what a republic stood for. Now, one principle that emerged over the course of our early years is this idea of majoritarianism. But even that was contested, right? Who is the majority? Who counts for purposes of determining whether government is Republican? And there was a lot of disagreement about that.
Right. Yeah, I think, it's kind of a calling card of the Federalist Society to answer everything with, we're a republic, not a democracy. And I actually think there is something racist and sexist inherent in that idea, even if they don't mean it that way. I do think there, and something about class too, I think, in that idea. All right, well, let's go to your book, because I'm so excited by this title. In Congress We Trust, Enforcing Voting Rights from the Founding to the Jim Crow Era. Is it pure history? Is it analysis? What is the book going to be?
So the book is a lot of it is history, although I do conclude with the normative implications of that history, because I do think that the historical part of the book, the whole point is to show that Congress has been more proactive with regulating elections and voting than we give Congress credit for. And the reason this is relevant is because the court's current position is, very federalism centered, right? They view it as a state regulated process. They think of federal intervention as something that should happen only sparingly. The reality is that they're looking at Madison's Constitution, but they're not looking at the, Civil War post-Reconstruction Constitution and thinking about this. But even taking that off the table, because honestly, I don't think that point is new. People have made the point that Reconstruction fundamentally changed the relationship between Congress and the states in this space. But my point is that actually Congress had a lot more power prior to the Civil War that they used to intervene in elections in a way that the court hasn't fully appreciated. So even the federalism narrative isn't an accurate characterization of the relationship between the Congress and the states prior to the Civil War. And so that's one thing, that's another myth that I'm trying to dislodge. And in some ways, the book was inspired by Shelby County, right?
Sure.
If you read Shelby County, the decision is bankrupt of any discussion of not only the post-Reconstruction Congress and how active Congress was in trying to make sure the Southern states had Republican governments, right? They completely reset the baseline for what Republicanism meant. But it's also bankrupt of any discussion of how Congress was intervening and regulating elections prior to the Civil War. And it's in my head, I'm like, well, if you're going to focus on Madison's Constitution and you're trying to get us back to the pre-1868 version, why aren't you talking about these other things either? So, right. You know, the genesis of the book really is sort of my anger and frustration with the court and how they view Congress's power.
That's interesting, and I agree 100% with everything you just said. And I'm curious if you're going to agree with what I'm about to say, and you may not. The way you said that about election law, voting rights, and all that, is what I talk about all civil rights. Congress has been to the left of the United States Supreme Court on civil rights, with the exception of 15 years maybe, from 1960. I don't count Brown. I mean, Brown is Brown, and then we have nothing for 9 years or so, 8 years. So right. Let's say the early 60s to the mid 70s, 75 or so. Other than that, Congress has been to the left of the Supreme Court forever, in my opinion, when it comes to the rights of traditionally disadvantaged groups, which is why I despise the court so much, especially one of the reasons, especially when it comes to its relationship to Congress. And the last thing I'll say before I ask you a question is Oliver Wendell Holmes said, we could live without judicial review of Congress. It's judicial review of the states that we need. Now, he may have been talking about it from a uniformity perspective, but I think he also felt, as deferential as he was to both the states and Congress, he thought we should be even more deferential to Congress. And I agree with that. But when I say that to most liberals and most progressives, they start yelling at me and say, there's no help if it's not the Supreme Court and all this. I say, no, they only helped for 20 years. Then they bring up Obergefell, and I say, you're right. That's an exception. All rules have an exception. But generally speaking, the Congress has been way to the left of the court for most of American history on civil rights. Do you agree with that?
I do think I agree with that, and I would even go maybe a little bit further, right?
Nice, so great.
Brown was 55. There was a Civil Rights Act in 57, right? Yep. So it wasn't a very strong one, which is why most people overlook it. But Congress did do something, right? So I do think Congress has largely been to the left, but I wonder. So this is actually a hard question for me when you think about questions of judicial review, because to what extent do the branches kind of like feed into each other and respond to each other, right? To what extent do things happen because one branch has moved and then the other branch feels obligated to move, right? And so to the extent that we are distrustful of either Congress or the courts, I do think that they work in opposition sometimes in a way that actually favors progressive ideals. And so it's entirely possible that Brown happened in 55, and by 57, Congress felt like they had to do something, right? Because the court was already at the forefront. And would we have gotten a 64 Civil Rights Act had the court not, in 59 and Cooper versus Aaron said, look, we made this decision, 58?
58, yeah, and Brown was 54. Right. Sorry, go ahead.
Yeah. So I always think about Brown, too, since Brown
That's
won.
Fair. That's fair. For those, Franita, not everybody listening are lawyers and common law professors. Brown 2 said the states had to enforce Brown 1 with all deliberate speed, which in effect meant never, because in 1963 the South was still completely segregated. So.
Right, exactly. And in 58, Cooper versus Aaron, the court stood by the decision in Brown and said that states had an obligation to desegregate. But I do think the sequence of events made Congress feel like they had to do something. And so I don't think that we can think about this question of the court's role without considering the fact that the branches often act in opposition to each other in a way that might actually work for the greater good.
That's a great point. My friend Barry Friedman at NYU used to write very long law review articles about I think he called it the dialogical constitution. Barry, I hope I have that right. But I remember reading them when I was a kid, 1995. I think he wrote them in the 80s. But he was right, though, and he's making the point of all that work, which was a lot of pages, is the point you just made, and he really carried it out. That what we have is a conversation between the elected branches, the court, and the people. And that it takes all three kind of to get the court where it needs to go. I agree with all that. Where I disagree with Barry, and I'm not sure where you stand on this, is I think we could still have that with much more deferential judicial review. Not no judicial review. I'm not in favor of that. But I think if we had clear error judicial review, the kind that... Okay. Are you with me on that? It's hard, I know.
It is hard. And so what do these words mean? And let me explain why that's my question. Couldn't congruence and proportionality technically mean clear error? Like these words actually don't mean it. They are devoid of context if you think about of content without context, because the standard that the court currently applies, the court doesn't apply consistently. Like, can you explain to me why portions of the Americans with Disabilities Act or the Age Discrimination and Employment Act
are
different from the Voting Rights Act, right? Like, the court has purported to review congressional acts under the 14th Amendment pursuant to this congruence and proportionality standard without providing an objective sense of what that means. And so even if we change the standard, what does that really get us? Because technically the court could be deferential using the words congruence and proportionality. It's just that the court doesn't want to.
Well, this is an issue I have. Well, I wrote a whole book on it, so I've given it a lot of thought. And I do think that judges understand burdens of proof and standards of review. So the analogy I give all the time, Court of Appeals judges really do defer to district court judges on factual findings. Not always, but and the judges I know personally, at least before the Trump era, hopefully after the Trump era, they take that standard very seriously. They really do. And they're not going to now they may, in a very politically charged case, they might or might not, use that standard. But they do like 95% of the time or something. They understand what it means. I'm only going to reverse this decision if I can write an opinion that shows it was clear error. I don't think Shelby County can be written honestly. Well, it was written dishonestly anyway. But in an honest world, I think clear error review might have saved that statute if we had a tradition of clear error review. We don't have that. It's kind of like rational basis tests for economic laws, right? I mean, the court has been able to enforce that standard pretty well.
Yes, but usually we're arguing about the 5%, not the 95%.
That's true.
Right? And then because of the 5%, that's how we end up with rational basis review with the bite. Right? That's another
Fair enough.
That's another way of trying to skirt the hard questions.
I agree. So the title of your book refers to the founding to the Jim Crow era. And I'm kind of curious when you think the Jim Crow era ended. Because it wasn't 1964, I can tell you that. I have people...
No.
Yeah.
So the book goes to the beginning of the Jim Crow era, which I think is a little bit easier to pinpoint.
Yes.
It's the late 1880s, early 1890s.
Yes.
Even though Reconstruction, really Reconstruction, one thing I'm finding in my research is Reconstruction really ended like 1873, which is not something that we talk about. It ended with the Panic of 1873 functionally ended Reconstruction. I know everybody loves to talk about the 1876 election, especially in light of our current circumstances. But Republicans, once they lost control of Congress in 1874, it was a wrap. In some ways, the 1875 Civil Rights Act was really sort of the last dance, right? It was a statute passed as a memorial to Charles Sumner. But
explain what it was. Explain what it was.
So the 1875 Civil Rights Act looked a lot like the 64 Civil Rights Act. It prohibited discrimination in public accommodations, movie theaters, restaurants, and things of that sort. There's a really famous article by Michael McConnell where he argues that school segregation actually comes within the sphere of the 14th Amendment because it was debated as a part of the 1875 Act, even though they ultimately took it out, right? But they sort of thought that their power reached banning school segregation.
Just for the record, I think his article, I love Michael McConnell. He was a huge inspiration to me about judicial review earlier in my career. That article is ridiculous and it's terrible, and I'm sorry it's gotten all the press it has gotten. There is no scenario where the original meaning of the 14th Amendment in 1868 meant states couldn't segregate schools. I'm just going to go into there just isn't. It doesn't exist. It's not there. I don't care. Go ahead. Sorry.
So I will say that I agree that there's no scenario in which the 14th Amendment was designed to outlaw school segregation.
Yes.
I will agree with that. But that only matters if you're an originalist.
Right.
Which I'm not.
Yeah, I don't have that faith either, as you know. But go ahead.
But the Supreme Court struck down the 1875 Civil Rights Act in 1883. And it kind of goes to the earlier conversation we were having, Eric, about how the branches kind of work in opposition to each other. It's like the Supreme Court's pushing back against this expansive reading of the Civil War amendments, and Congress was trying to push forward. And even as late as the 1890s and turn of the century, Congress was having conversations about enforcing Section 2 of the 14th Amendment against the states that were still disenfranchising people, right? People think that Congress quit with Reconstruction ended. No, Congress was using its power under Article 1, Section 5 to review the elections of its members, to refuse to seat people who were elected in fraudulent congressional elections, right, where Black people were disenfranchised, where there was fraud and violence. They were trying to, so Section 2 for people who are not well steeped in obscure constitutional provisions is a provision that allows Congress to reduce a state's delegation in the House if the state abridges or denies the right to vote of its citizens.
Well, it's male citizens, right?
Well, as amended by the 19th Amendment, though, in my view.
Yes.
There were discussions in 1901 about enforcing that against certain states that were still disenfranchising folks. And importantly, it's race neutral. It just talks about abridgment or denial. So it's different from the 15th Amendment. So I think if you look at that history, it's fairly easy to pinpoint when Jim Crow started. Much more difficult to pinpoint when it ended.
Yeah, I'm not sure it has. I think it's just, as I forget her name wrote, it's just been sent to the prisons. But let's not get into that right now. Yeah, the new Jim Crow, So can you, this is such an unfair question, but can you kind of sum up in a few minutes some or many of the ways that mostly southern states, but not just southern states, kept African Americans from voting from the really 1870s until the mid 1960s, late 1960s, and I know it goes through today with other things. But can you kind of sum that up? I'm not sure everybody knows that story.
No, absolutely. And I think the story actually makes an important point about voter suppression being contextual, because a lot of the things that we look at now as being sort of run-of-the-mill voting regulations were actually used in suppressive ways in the past. So a common one is voter registration. Right now, everybody registers to vote, and some states do have same-day voter registration. But generally speaking, it's not unusual to have a registration deadline that's a month out. In the 1870s and 1880s, a lot of southern states passed laws that made voter registration requirements that were sometimes as much as 4 months out, right? Mississippi was notorious for this. But some of the other requirements are, you have to have an address. And a lot of the former slaves they lived in houses that didn't necessarily have addresses, right? Very similar to what we saw in South Dakota, where Native Americans who lived on reservations didn't necessarily have addresses, and they passed a voter identification law that required ID with an address.
And we know why they did that.
Exactly. So a lot of this stuff is contextual, and we look at these things as, this doesn't happen now. This is from 100 years ago. And I'm like, no, voter registration, they gerrymandered a lot, right? So Mississippi in particular, and Mississippi is a state I love to beat up on because my parents are from Mississippi, and I continue to believe it's like the worst state in the union. But in 1890, they actually led the charge with changing their requirements under their state constitution to disenfranchise African Americans and poor whites. And so then the rest of the Confederacy basically followed Mississippi because they were very effective. The difference between 1888 and 1892 is that African American turnout went from about 30% to close to zero. That's how effective they were. And so other states followed suit because they also wanted to depress that population. So the interesting thing too that people don't realize is that those state constitutions were race neutral. So they did not, on their face, mention race. They really did rely on discriminatory application by election officials in order to be truly effective. And so it was also a way of getting around the 15th Amendment and trying to preempt any federal involvement.
Right, right. Can you talk about literacy tests for a minute?
Yes, literacy tests and poll taxes. How did I forget those? Right. Some of these state constitutions required individuals to read a provision of the state constitution, and this was during a time where the literacy rates were very, very low. So it was difficult for a lot of people to do that. But this is where the discretion of election administrators became very important, because if they had a white person who couldn't read, they could just say that they passed the test.
Right.
But if they had a black person who could read, they could just fail them. Right. So this is where discriminatory implementation was very important. Poll taxes. Poll taxes were very, very effective. Let me just mention briefly Georgia's poll tax, where it was cumulative. So if you didn't pay it one year, it just continued to accrue
nice.
So you could pay it.
But I don't think whites paid the poll taxes, right?
No. It's they had no interest in actually collecting the poll tax, right? It's a tax that was never enforced, which is contrary to the idea of taxes. But it was quite effective at basically cutting African American turnout in Georgia to the bare minimum.
So one of the things I don't think a lot of people know about literacy tests. So I think a lot of people have seen them on the internet or someplace. These were tests that I'm sure I could not have passed in many cases, and I doubt very few con law professors could have passed in many cases, because the questions often made no sense. There was no answer. But
and
the point.
Time.
Say again.
And it's time.
Yes.
So even if you get all the questions right, I doubt you can answer 60 questions in 15 minutes.
Right. But and these tests were used throughout the South to really disenfranchise African Americans. But the point I want to make about it, that a lot of people don't, I found out that most lawyers don't know this. In fact, I found out most non-constitutional law professors don't know this. The Supreme Court upheld literacy tests. That's the amazing thing. In 1959, 5 years after Brown, I think it was 59, maybe 58, but I think it was 59, in Lassiter versus North Carolina, they upheld them. It took Congress to eventually get rid of literacy tests, which is another example, a very important one, I think, of the Congress being much more progressive. And the person who wrote the opinion in the North Carolina case was Justice Douglas, who was one of the most progressive Supreme Court judges ever. I think that opinion is unmistakably horrible in 1959, given what they knew was happening.
Yes, but I've wondered this. Okay, so 2 points. The first is that if anybody who takes election law with me has taken a literacy test, because I make my students take it.
Good,
the Alabama 1955 literacy test, they have to take it.
Good.
But second, I wonder the extent to which the court. Lassiter is a product of a Supreme Court that had been very active on racial issues. Because keep in mind, we talked about Cooper versus Aaron. That was a year. Lassiter was decided a year later.
Yeah.
And so if you're the court and you just had to reassert your authority, right? You had to basically make a statement saying, we decide what the Constitution means, right? Cooper versus Aaron is important because it's one of the strongest articulations of the court's role since Marbury versus Madison, right? So it makes me wonder if Lassiter is a response to that, right? Lassiter is so horrible, but maybe that's the only way I can make sense of it, right? They had already rocked the boat so much that Lassiter was a time in which they decided to take a step back and let things cool off.
What I find fascinating about your comment about that is so Brown is 54, Brown 2 is 55, Cooper is 58. And that did involve Arkansas and one good deed by the court and the National Guard. But it is still true that in 1959 America, the South is completely segregated. And not just schools, but parks, prisons, phone booths, everything was segregated.
Yes.
Lassiter is unforgivable in the context of a completely segregated America 5 years after Brown. That's...
Look at the bookends, though, right? Look at the bookends. You have Cooper in 58. You have Gamillion in 60. You have Baker versus Carr in 62. You have Reynolds in 64. Like the court, Lassiter is remarkable for being a terrible decision in a decade in which you had great decisions. right? And so that's why I just feel like deep in my the pits of my soul, something else had to be going on, but because it makes no sense, right? How is the court aggressive on all of these? Gamillion is really like Reynolds versus Sims.
Well, tell people what that is. Tell people what Gamillion is.
So Gamillion, the court articulated its willingness to police racial gerrymander. Right. The Gamillion, the funny part about Gamillion is that they were able to gerrymander in Alabama in a way that was completely effective without really having the technology that we have now. Right. The city of I'm trying to remember which city it is. It's where Tuskegee is.
Is it Mobile?
It's not Mobile. I want to say maybe Tuscaloosa. I don't know. I don't remember. But the city in Alabama, they drew a 28-sided figure that put all of the black people outside of the city, outside of the district, right? And all of the white people in the district. And so basically the black people had no political power. And they did this without having the technology that we have now. But more importantly, the court said that this is a potential constitutional violation. And the court was willing to sort of police this domain, even though, and the interesting thing is, Frankfurter wrote that opinion, but he had also written Colgrove, which was, I guess, about 12 years earlier, where the court basically said that it would not weigh in on questions of
hands off
political power when it comes to drawing districts and such, right? So the fact that the court was willing to be more aggressive in this space, if you look at that decision and then consider that Lassiter was the year before, it just makes no sense.
You mentioned earlier that your parents are from Mississippi and you think it's the worst state. I'm not going to get into a battle over what's the worst state, but I will say that the civil rights activists of John Lewis's generation, I think, thought that Alabama was the worst and Birmingham the worst of any city. You know, Birmingham and Mobile, well, Birmingham, not Mobile, Birmingham in 1964 was just, it was just apartheid. It was apartheid all out, full force, as much or more than any other American city. We're running out of time. I want to. This is not a fair question. I'm asking you an unfair question right now, but you're really smart, and I'm really interested in your take on it. And I think this is, it's about democracy and elections, and free speech. I think it's the most important question facing America right now. How does a democracy, or even a democracy / republic, whatever, how does a free country, a country that believes in freedom of speech and free elections and racial equality in theory, and gender equality in theory, how does a country that believes in all of that fight anti-democratic elements in its own citizens? How do we fight against people who don't want those freedoms when we are bounded by our commitment to those freedoms? I have no answer to this. That's why I'm asking.
So I have a couple thoughts about that. The first is, don't assume that the fight ever ends, right? We've always been fighting against these elements. And I just think that the Trump presidency has brought out the worst of them, but the worst of them recently. They've always been there. There's always been this very interesting duality to America where we're both the people who turned out in Georgia to vote and turned out in historic numbers in a special election, which is, special elections are a form of voter suppression. They are designed to only turn out the most impassioned partisans, right? It's a tactic, especially in Georgia where there's an ugly history behind it. But people turned out because they felt like their votes were the best way of articulating their dissatisfaction with the status quo. Less than a day later, another segment of our population turned out because they're dissatisfied as well, but they used violence, right? That's two visions of America, but it is America, right? And so part of the reason why this fight is always ongoing is because we have to push back against who we don't want to be, and we have to build up who we want to be. And I think, hopefully, and I believe this, the majority of Americans identify more with the people who cast ballots in Georgia than they do with the people who stormed the Capitol.
Yeah.
So I don't think that there's a permanent fix in a sense. I just look at it as an ongoing battle. But one thing I know that's not the right answer is this: we have to turn the page and we have to heal, and we can't move forward without accountability. We can't move forward without, being clear in our repudiation of what happened on Wednesday. There has to be consequences, right? Otherwise, we don't really deserve the title of democracy. That means that they win. right? The part of America that we are rejecting wins if we don't do anything about what happened.
I agree with that. Was well said. I guess where I feel a lot of tension, and people like Jeffrey Stone, who I really respect, and Jeff, he was actually, we had a podcast. He's one of the great defenders of maybe the greatest defender of free speech among modern law professors, University of Chicago. He and I agree on 99% of things. He blurred my book, but we disagree on this. I have kind of a European perspective on free speech. I'm the guy always invited to be the one American law professor who is not a free speech exceptionalist. And there's a tension to me between recognizing the free speech rights of people who will then deny free speech to other people. In other words, if their line was, we want everybody to speak freely and everybody to be equal, but we think X, Y, that's one thing. But attacking the Capitol is attacking, in my view, free speech in a way. I mean, it's using violence. They have a right to say we're upset with the election, we think there was fraud. They have a right to do all of that. They don't have a right to storm the Capitol. But the speech led to the storming of the Capitol. And Europe would, in most countries, stifle the speech. And I'm not saying that's the right answer, but I think it's a serious tension Americans don't think. We need to think more about that idea, that sometimes speech really is harmful and really has to be blocked.
I'm not opposed to regulating it. And I know that that's probably bad to say, but keep in mind, I also think campaign finance laws are important.
Yeah.
So, to the extent that speech is a marketplace, we regulate every other marketplace, right? Like, we live in a capitalist society, but it's not free of regulation.
Right.
Why do we make the comparison of free speech as being a marketplace of ideas and then proceed as if that marketplace doesn't need to be regulated? It does.
That's a great point. My colleague, my former colleague, a former colleague of mine wrote a book saying applying free market capitalism to elections is an incredibly dumb idea. And I think that's where we get campaign finance reform invalidations by the Supreme Court. And I think, obviously, corporations have some rights. The government can't go into the New York Times and search it, without any warrant and all that stuff. But the fact the New York Times has some rights doesn't mean Exxon has the same rights as you and I to participate in our elections. And I can't.
Right.
It's so hard to get conservatives to see that, but to me, it's such an obvious point.
Yeah.
Yeah. All right. On that kind of somber note, Franita, thank you so much for doing this. I know your time is very spare, so thank you so much for doing this.
I appreciate it. It's a great conversation.
I really appreciate it. When COVID is over, we're going to do something in Atlanta, I hope, and I hope you can make it. But we have to wait till COVID's over, though.
Yeah.
All right. Take care. Thanks a lot.
Take care.